This is going to be 5 minutes at 200 straight through. 5 minutes at 200 jury charge straight through. Ready? Now that you have heard the evidence and the arguments, it becomes my duty to instruct you on the law. It is your duty to accept these instructions of law and apply them to the facts as you determine them. As I mentioned at the beginning of the trial, Mr. Jones has brought his claim under the legal theory of violation of his civil rights. The defendants deny these claims. The theory requires proof of different elements. Later I will instruct you on the theory. First, I would like to give you some general instructions. You have listened carefully to the testimony that has been presented to you. Now you must pass upon and decide the fact issues of this case. You are the sole and exclusive judges of the facts. You pass upon the weight of the evidence. You determine the credibility of witness. You resolve the conflicts as there may be in the evidence, and you draw such reasonable inferences as may be warranted by the facts as you find them. I shall shortly define the word evidence for you and instruct you on how to assess it, including how to appraise the credibility, to put it another way, the believability of the witnesses. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. You are not to be concerned with the wisdom of any rule of law stated by the court, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions I am about to give you, just as it would be a violation of your sworn duty as judges of the facts to base a verdict upon anything but the evidence in the case. Nothing I say in these instructions is to be taken as an indication that I have any opinion about the facts of the case or what the opinion is. It is not my function to determine the facts. That is your function. You are to discharge your duty as jurors in an attitude of complete fairness and impartiality. You should appraise the evidence deliberately and without the slightest trace of sympathy, bias, or prejudice for or against any party. All parties expect that you will carefully consider all of the evidence, follow the law as it is now being given to you, and reach a just verdict regardless of the consequences. As I have said earlier, it is your duty to determine the facts, and in so doing you must consider only the evidence I have admitted in the case. Statements and arguments of counsel are not evidence in the case. When, however, an attorney on both sides stipulate or agree as to the existence of a fact, you must accept the stipulation and regard that fact as proved. As I mentioned, any statements, objections, or arguments made by the lawyers are not evidence in the case. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. The evidence includes any stipulated facts, the sworn testimony of the witnesses, and the exhibits admitted in the record, any evidence as to which an objection was sustained, and any evidence that I ordered stricken from the record must be entirely disregarded. Also, during the course of the trial, I may have occasionally made comments to the lawyers, asked questions of a witness, or admonished a witness concerning the manner in which he or she responded to the questions of counsel. Do not assume from anything I have said that I have any opinion concerning any of the issues in this case, except for my instructions to you on the law. You should disregard anything I may have said during the trial in arriving at your own findings as to the facts. While you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions, which reason and common sense lead you to draw from the facts which have been established by the evidence in the case. The law recognizes two types of evidence, direct and circumstantial. Direct evidence is provided when, for example, people testify to what they saw or heard themselves, that is, something that they have knowledge of by virtue of their senses. Circumstantial evidence consists of proof of facts and circumstances, from which, in terms of common experience, one may reasonably infer the ultimate fact should be established. The following thing is a simple example of circumstantial evidence. Assume that when you came into the courthouse this morning, the sun was shining and it was a nice day. Assume that the courtroom blinds were drawn and you could not look outside. As you were sitting here, someone walked in with an umbrella that was dripping wet. Then a few minutes later, another person also entered with a wet umbrella. Now, you cannot look outside of the courtroom and you cannot see whether or not it is raining, so you have no direct evidence of that fact, but on the combination of facts that I have asked you to assume, it would be reasonable and logical for you to conclude that it had been raining. That is all there is to circumstantial evidence. Such evidence, if believed, is of no less value than direct evidence. As a general rule, the law makes no distinction between direct and circumstantial evidence, but simply requires that you find the facts in accordance with the preponderance of all the evidence in the case, both direct and circumstantial.